Welcome to Property Chat with Lucy, where real estate meets real talk. I'm your host, Lucy, and I want to take you through a journey of the basics of real estate, unfair, at times traumatizing stories in real estate. You're gonna meet industry experts here, and also I'm gonna share with you market trends on real estate, so you don't wanna miss out on this. So look forward to an amazing time with me as I get you into my world of real estate. Every episode, I intend to educate you, inform, and inspire you. So stay tuned to this. Hello, my lovely people. Welcome back to another episode of Property Chat with Lucy, where real estate talk gets real. Today, I want to advocate for your rights as a tenant. You have been in your journey of renting out premises, whether an apartment or probably, let me just say, a residential accommodation for yourself or a business premises for yourself. We're going to dive deep into your rights as a tenant before getting into the lease agreement, during the tenancy agreement, and at the point where you're exiting. This is just because I've met a lot of you in very compromising situation, which has brought me to know that quite a number of us are not aware of our rights as tenants. For me to just go through this together, I have none other than Mimi. You've seen her on my platform. And for the sake of the new people around here, I'll let her introduce herself.
Thank you for having me again. I feel like I'm such a regular now.
Yes, you are.
So for those who are tuning in for the first time to Lucy's podcast, my name is Mimi Aldrin, managing partner advocate, commissioner for oaths and notaries public, managing partner of Amulioto and Company Advocates, or ANC Advocates, here in Nairobi. And I'm happy to be here again.
Yes.
Yeah.
Good. Before we dive into your rights as a tenant, I thought of just bringing in the introduction bit just to give you a glimpse of some key things as a tenant before you think of renting out any space you need to look into. Mm-hmm. One, I would say you need to get a realtor and you need a lawyer. And that is why I am seated here with a lawyer, and we're going to get into the depth of this matter. And number two, you need also to understand that it's good to have the lawyer look at the lease agreement, discuss with the realtor on the terms, so in case of any eventuality, you're able to know what recourse you have as a tenant. So let's dive into the rights of a tenant before coming on board.
Okay.
Yes.
So the most basic thing is you have to know what it is you're looking out for, and that's where the realtor comes in.
Yes.
Because your right can only be effected based on something that's in existence, and that is the premises that you're looking at, be it an apartment, be it a townhouse, whatever it is you're looking for. So the realtor now will work with other professionals to be able to make sure that whatever it is, the size you're looking for and all the things that you know how to look for, meet what the prospective tenant is looking out for. So if I'm looking at 10,000 square feet or 1,000 square feet, you are the one who knows, how the measurements are done. And for us, by the time someone comes to us, I will ask you, have you looked at the building plans? Have you looked at, are you going into something of sectional properties type? So have you looked at the sectional plans? Have you talked to a surveyor? Have you talked to your realtor? Have they connected you to the architect or an architect to confirm the drawings? So your rights now begin there when you're now doing that due diligence on the documentation, on the properties. Are there approvals? Is there a certificate of completion? How many people actually rent out premises that are at 80% and there's no certificate of completion? So you're finding there's construction going on in Block A, but there are so many people already living on Block A. Why are you exposing yourself to extensive injuries, risk of harm and damages, illness, just because you've not done your due diligence to make sure that there's actual certificate of completion and occupation, because if it's not been certified for occupation, what are you doing there? Because then who are you going to sue when the risk was evident? It was very foreseeable. There's something called foreseeable damages, right?
Let me just dive into that a bit in the realtor's perspective.
Right.
I have been in the market for quite some time,
Right.
and I've seen huge mistakes tenants make, where you just go in, look around, you get something that you like, you commit yourself, and then at the end of the day, you realize maybe there are things you're not looked out for, like security.
Right.
If whatever you're paying in terms of rent is actually, I would say, market rent. Because there are situations where landlords will get more than what the market is asking. And that's where we come in to negotiate a fair market rental value for you.
Yeah.
And in terms of looking at the offer letter that we normally draft,
Right.
but also with the assistance of your side of the equation,
Yes.
I've seen quite a number of tenants are not aware of those terms.
Right.
And I wanted to just dive into that. And then in terms of the legalities where a tenant will find this has been violated,
Right.
what's the recourse on that? And one is right to privacy.
Right.
Okay.
That's a biggie.
You have a business premises. There's a law that probably we will touch this separately, but I could just mention commercial premises. A landlord should never just come in.
Right.
And I think also residential.
Absolutely.
To just come in at any given time to coerce you without a reasonable notice.
Right.
What does the law provide within that space?
So technically, for once you've let out a space, whether it's a rental in terms of residential or commercial, you must give sufficient notice. Now, the abuse is in the word sufficient or reasonable, because someone will say 1 hour is reasonable notice, and it really isn't. So if you give someone at least 48-hour notice, they're able to put their documents together, they're able to put their personal effects together,
Yeah.
because you can't just assume that just because it's your premises, you own the space, that you own everything absolutely. You know what we call in law ad infinitum. You need to be able to give the person enough time to get their affairs in order, just so that when you come in, you're not violating their right to privacy. It's
Yeah.
actually a constitutional right. So in that aspect, you also need to know who your landlord is. Remember, you said something very interesting about paying landlords more than market value.
Yeah.
But are you actually paying the landlord, or are you paying someone masquerading as the
The
landlord?
landlord. Oh, wow. Yes.
Because the landlord could be getting some money from this person, but this person has no contract with you whatsoever, rather with the landlord. There's a way the money is being channeled to the landlord. So the landlord is aware that there's something going on with the premises, but they don't know who the tenant is, have not signed an agreement with the tenant, but the tenant has signed an agreement with somebody purporting to be a landlord. So the due diligence aspect cannot be escaped. When you're signing that agreement, who are you signing it with?
Yes.
You have to verify. If it's a company, you have to do the search in the company's registry, which is now under the BRS, Business Registration System, on your eCitizen portal. Make use of such things. Everyone has an eCitizen portal, but they don't even know how to navigate that portal in their favor. So come to us, pay consultation to an advocate.
Yeah.
Let the advocate either do it for you or advise you on how to do those searches for
Yeah.
yourself,
Yeah.
so that you're covering your bases in the event of a company. If it's a person, ask people around. If you're hearing this particular landlord has 10 units, all right, find out who those are the 10 tenants are, and find out that you're actually dealing with the right person, so that you're able to pay the rent to the right person. So that this person is the one giving you now the notice, proper, sufficient notice, to be able to enter your premises at any given point in time. And they can only enter those premises during daytime. There is no night searching. There is no night inspection. Those are called night demons. You need to be able to be coming on the premises reasonable time. And this reasonable time applies to eviction notices. It applies to searches. Even the searches done by police officers.
Yes.
It's supposed to be between 6 a.m. and 6 p.m. for also whatever the landlord wishes to do, whether it's an inspection or whatever,
Yeah.
on the premises. Right.
Oh, wow. I want to just get back to now the structure,
Right.
which I feel like also this is a space where a lot of people, you just meet a landlord and they tell you, I am letting the space as it is. All right? But then there's a right to you as a tenant that you need to get habitable,
Premises,
space,
yeah.
or premises or whatever it is. What does habitable in law mean?
Yeah.
In terms of whether a tenant gets in and they realize there are leakages, there's overheating of
Right.
wires in the rooftop,
Right.
probably there's plumbing issues.
Right.
So does such a tenant has recourse to, get a bit of compensation if damages happen within the
Right.
premises?
So there's something called latent and patent defects. So there are defects that are visible when you inspect, and then there are those defects that you will not be able to know until much later. But you'd be able to mitigate that part by having an engineer, particularly a structural engineer, come and assess how the space is before you get in. This applies to tenants, this applies to purchasers. You need all these professionals, certified professionals. I'm not talking about someone who's learned on the job. I'm talking about someone who actually went to school, because they'll be able to tell you structurally, this building is not sound. So give it 5 years, something bad is about to happen. Or give it 3 months, if there's any kind of tremor in Nairobi or wherever, something bad is about to happen. So there are those kind of defects that you wouldn't be able to know. But you'd still be able to see some structural defects, maybe cracks on the walls, that they're trying to seal, they're trying to conceal and seal as much as possible, but there are still cracks on the walls. You'd be able to look out for these on particularly bathroom walls, particularly pantry walls, because that's the place they really don't try to hide it as much. Where there's been some gypsum ceiling right behind in the corners and the cracks of the gypsum ceiling, there could be some crack that they have not sealed. So when you're doing that initial inspection, take your time. Don't rush. Get your professionals on board. Pay them for the day, but make sure you're actually getting into habitable space. And while you're doing that, you'll be able to see some defects that are in the obvious, quite obvious. Like now, the windows are not closing properly. They're not able to seal properly. The door handles, the window handles are not closing properly. The door does not close. That is a safety issue. And that is your right. You have a right to safety. The hot water is not turning on. That's one of the most common issues people face. You're told you have an instant water system, but every time you test that instant water, it does not come on. You're told then buy some tokens for Kenya Power. But the token system requires you to charge it. You have to remove it, charge it. Those are some of the things that we're talking about when you're inspecting the premises. The tiles. Have you ever stepped on tiles and they have different sounds?
Yes.
Each tile has a different sound. So your house keeps singing to you every time you walk in. Now, those are some of the things that we're talking about. For new premises or recently repaired premises, this should not be the case. Cracked tiles are a safety risk. Some people trip over uneven staircases as well. Because if the staircase is supposed to be 1 centimeter, or a few centimeters, then you find one that's a few centimeters above the measurement. Do you know your brain tells you to lift your foot at that centimeter every step? So when you get to the one that's not as per the scale of the others, you will trip. Those are some of the things you're supposed to be looking, and those are very obvious defects that you can look out for.
So in that mindset, we had heavy rains.
Right.
That spoiled people's properties. Right? This is something no one probably projected that something like that would ever happen. I would also give an example where someone has tripped over a staircase to a point where unfortunately maybe a death occurs out of that. Those tenants, do they have recourse to sue?
Yes, especially if you were given the impression that the structure was sound, that the drainage system was sound. Because remember, just because we're building on black cotton soil does not mean you cannot mitigate that in your construction. The drainage must be sound as well. So in me inspecting the premises, fine, there are things I may not be able to tell. Like I've said, there are those latent and patent defects. But then you have to show me, as someone who's doing my due diligence on the space, and which is why you need your professionals, that this is the waterway, and that it's wide enough and deep enough and clear. It could be wide and deep but full of garbage. It's clear enough such that the water will drain outwards out of the premises. Then if this structure that you want to live in as a tenant has a basement, how do you mitigate the flood water when it starts to go into the basement. So what do you have in place in terms of how you constructed this premise? Right from the structural drawings, I will look at the drawings with the architect, look at everything with the surveyor, and be able to tell, listen, the way the slanting is of this area, together with the way this has been put up by the engineer, have they reinforced it enough, and does it have enough drainage, sufficient drainage and lighting? Because also with floods come lighting issues. Depending on how everything has been done. Because with the drawings, you'll also be able to tell the electrical system. There's so much you'll be able to tell in terms of due diligence if you're really serious about the place you want to either live in or purchase. And these are things that I think every tenant should be interested in. Do you know there's risk of electric shock during a
Yes.
flood?
And also the instant showers.
People are getting shocked because they're using substandard materials, substandard equipment to be able to put up those showers. Those are some of the things. It's very small, but then later on when you get that shock, that's the day you'll realize you need to have done these checks before. But that does not stop you from having legal recourse because it's both ways. Even when I do my recourse, you still were supposed to have made sure at the point of construction, at the point of letting out the space, that it is habitable, that it complies with health and safety.
I have a very big question there, and this is where you lawyers, at times, I feel like, how practical is it to compensate, or rather, the cases you've seen where a tenant has lost that, they've not been given that privilege by a landlord. It's not out there in the market that they can actually sue landlords for this. We have this domineering mentality that landlords are here, tenants are here.
Right.
But then, if it were not for the tenant, the landlord would not be here. You get it? Have you seen successful stories where tenants have been compensated?
Yes, it does happen. It
Oh,
does
wow.
happen. But you see, that's the thing. Civic education is very important, and that's why your platform exists. Your platform is reaching out to the people who do not know what their rights are. There are a lot of tenants, there are a lot of people purchasing apartments and townhouses and things like that, and they do not know the extent of their rights. So you need these platforms like Property
Yeah.
Chat with Lucy,
Yeah.
just so that you're able to know. And then also make use of Google. Google is actually your friend. Make sure you Google certain things because it will open up your mind to the scope of your rights and the success rate. Those who actually sue and have evidence, remember, suing does not mean you've won. Suing with good evidence, good enough evidence, makes sure, it will show that you've won. If there's even a thread of emails showing that you've been reaching out to the landlord talking about these things that you've discovered along the way. For instance, this shower, every time you switch it on, there's something funny happening with sparks and things like that.
Yeah.
If you've been notifying the landlord, you've even made you have email correspondences with the electrician trying to figure out, but the electrician would not necessarily, an external electrician without drawings would not necessarily be able to know where the lines are meeting and why that is happening,
That's
even with
true.
good equipment. Sometimes the issue is not the equipment. Sometimes the issue is the lines. The conduit for the water plumbing and the conduit for electricals are meeting at a point where they're never supposed to meet. So these are some of the things you can sue for once you're able to get sufficient evidence.
Let's look at also another right, because you're talking about rights for the tenants once as they're coming in. So we've talked about habitable space.
Right.
There is also, once they are in, there's full disclosure by the landlord on any, I would say, if there's any charge in the property, because the corporates would do thorough searches.
Right.
And if the landlord does not disclose some of the, I would say some of the situations like a charge that has been passed on the property, then we end up getting all excited till the end, and then you realize we can't move with the letting.
Yes.
But then there are smaller tenants who just assume that all is good until you get a premises, and then your business, you sign up. The following day, you find those X.
Yes, yes.
This is a road reserve, right? So what would you advise tenants to do in this kind of situation?
Due diligence. Again, it just goes back to the devil is in the details.
Yeah.
Because don't rely on the landlord to spoon feed you all the information. They have to look good.
Yeah.
So they will give you some kind of information, but it's up to you to discover as much as possible about the place that you want to live in, work in,
Yeah.
whatever the situation is, right? And material misrepresentation by landlords is something that's actionable in court. But what is the extent of that misrepresentation or failure to disclose? Because where it meets your ignorance, the law cannot aid ignorance.
Right. So we've looked at inspect your premises before you sign.
Absolutely.
Do your due diligence.
Yes.
There's the big nightmare now. Lease agreements. I have given tenants lease agreements to sign,
Yeah.
and I tell them you need to have that document witnessed by an advocate. And there's a reason why we do that, because you are committing yourself and accepting that you've fully understood those terms.
Yes.
So one of the things I would say from a realtor's perspective, get a lawyer that you trust and they can thoroughly look into any offer letter. As much as, yes, a lease is the main document, an offer letter provides the predetermined terms or
Right.
a pre-agreed terms. And here are rentals, rent escalations that you're going to tell yourself. And anything that is going to be agreed prior to, or rather any change to those terms, it's another legal jargon of doing what we call addendums. So I want to bring that aspect of doing addendums.
Yes.
You've gotten into the list, and then you realize, even before you take possession of the unit, there's some terms that you feel like you committed without thinking.
Right.
What can a tenant do legally?
Legally, there's always room for negotiation. So the very first thing is to meet with your landlord or the person selling, depends on what the situation is.
Yes.
And seek for clarification of terms, right? This can be a meeting in person, or it can be by way of correspondences in writing. And once that is clarified, if it is acceptable to you to proceed, then you proceed. So you may not need an addendum
At that point.
if you're agreeable to the terms. However, if you're not agreeable to the terms because that's not what you're looking out for, and the lease is yet to be registered, then you do not need an addendum. What you need is the lease to be amended at that point and re-signed by the parties.
Yes.
Now, where you'll need an addendum is where the lease has been registered. Okay.
Yes.
Now, once it's been registered, then you'll need another document, which is now called an addendum, that only cites the clauses, the
been
specific clauses
changed.
that you're changing,
Okay.
or highlighting the terms
Yes.
for explanation purposes.
Yes.
And then when you're signing off the addendum, you co-sign, both the landlord and the tenant co-sign each of those clauses, right? So that no one claims later, listen, only signed the end. I didn't
Yeah.
understand what is in the middle.
Yeah.
So if there are 3 clauses only, you co-sign, small signatures against each of the clauses,
Yeah.
and then you sign and date, and it is again witnessed by an advocate.
An advocate.
Right.
Before we go to the rights within the tenancy, I want to just bring a bit of a clarification. The right to privacy before signing, it's where you share your very personal information to a landlord.
Right.
He does not have a right to share that information with a third party. There are documents when you're doing screening of tenants, if you're able, like your, I would say, credibility to get the space. We ask for bank statements.
Right.
We ask for your KRA pin. We ask for tax compliance certificates. We could ask for a passport if you're not a Kenyan. And this, one of the things I find tenants scared to share,
Right.
but they need to know you share that information in confidence, and the landlord has a right not to disclose that information to any competitor or even any other person
Right.
who is looking to take the same space.
Yeah.
And on that note, if he gets another person who probably has given an higher offer than yours, he has a right to communicate that to you. All right? So these are some of the things that I find tenants not quite aware
Yeah.
of what rights they have.
Yeah.
And
And just to jump onto that,
yes.
You see the point on not sharing. You don't need to sign. There are some tenants who are a bit woke, so they ask about non-disclosure agreements at the point when they are sharing personal data.
Yeah.
You don't necessarily need an NDA what you need to know is that there's the Data Protection Act, and that covers that kind of correspondence. So if your landlord breaches that by sharing your personal data, you can actually report them to the Data Protection Commissioner, and they've been fined heavily. There are companies, I won't mention them, it's been in the public domain this year and a bit of last year, that were fined up to 18 million just for breach of personal data.
Oh, wow.
Yes, so even your landlord collecting your data by way of, you've put down your phone number on your lease document or the offer, it has your phone number, your postal address, then you start getting all these spam text messages from the landlord. That is a breach of data. I did not sign up to receive data at the point of an offer. So when I don't even have to jump to sue you, I can just make a complaint to the Data Protection Commissioner.
Oh, I hope you're writing a bit of this, because I'm also learning.
Yeah.
Now, during tenancy, you've signed, you've agreed, I'll pay X amount every month.
Yes.
And then you don't, the economy is bad,
Right.
you know, you find yourself not paying your rentals timely. I know there is a clause we normally include that rent has to be paid maybe by the 5th.
Yes.
Failure to which the landlord can address the matter. And, you know, residential eviction is different, commercial eviction is different.
Right.
So technically, when I look at that, I am just trying to see what recourse do tenants have for unfair evictions when they don't, because mostly evictions come if someone is unable to pay rent. Yes.
Right. So if someone does not distress for rent, because there are options, I can try and distress for rent. So I just come with auctioneers as a landlord and see what I can pick up. So I'm not evicting you, but I want to collect the money. What I'd advise first is see if there are options for you to pay off the money so that you can stay, if you're still interested in staying.
Yeah.
Right? So the eviction also, there are rules as to how it needs to be done, just to protect the tenant from the landlord. Because a lot of landlords are rogue when it comes to evictions, whether they are commercial or residential.
Yeah.
They're being done late, during rainy weather, when it's dark. They start at 5 a.m. just to catch you off guard.
Or you find a padlock.
You find a padlock, I have a client who welded a door. So you find very strange occurrences when it comes to evictions. They're supposed to get an eviction notice. Eviction is not just, hey, sikutaki toka kwa nyumba yangu. It's not that simple. It actually can be that simple if you agree. So if the tenant is unable to pay, the landlord is supposed to write to them formally and give them at least a few days to respond. I'd say 30 days to respond is a good time, because within that time what happens is you're able to either get your resources together to pay off either whole or part of the amount with an assurance or a payment plan of how to pay off the balance. Or you make an agreement that, listen, I'm not able to pay, and so it's time for us to part ways. So when it's by mutual consent of the parties, then it becomes very easy for the tenant to leave. Now, where there was some time left, some landlords will insist on that time left. Maybe we've agreed on some time. You are here, you're supposed to be here for 5 years, or for 5 years and how many months, or 6 years, and then now you're leaving earlier because of economy.
Yeah.
There is actually a judgment in place where the court did not side with the landlord who wanted, and this is because a tenant's episode, this is a good judgment, where the court did not side with the landlord who wanted the balance of the rent that would have been accruing at that period of time. Because the court then said, but it is also your duty to find a tenant who can pay. Isn't it? So if this one can't pay and the economy is bad, find one who can pay.
Yeah.
Because you cannot find somebody who already is finding economic challenges, is going through economic challenges. And they have notified you they're going through economic challenges and they would like to terminate on that basis. They're actually sparing you by letting you know that they can't pay and they would like to leave. So
But
not unless you lower the rent,
yes,
you have options also as a landlord. If I notify you that I can't, then you have options. Either we terminate or you lower the rent so that I'm able to meet my obligations and you still retain me if you think it might be hard for you. Or I find you another tenant. There are several options that will escape the aspect of an unlawful eviction. So devoid of an eviction notice, devoid of you following a court process and getting a lawful court order for eviction in the event that you can't agree, then how are you evicting somebody from the premises?
Maybe just to mention that in commercial premises, eviction is different.
Yes.
And like in residential premises. I just want to dive a bit in the commercial space where we are seeing market dynamics taking us to a different direction where you even agree beforehand the terms of exit.
Yes.
Just in case
Yes.
that my business does not work, then these are my terms. I give you 3 months notice. You refund my 3 months, but I reinstate the premises. And this terms cannot be contained in the lease.
No, they're contained.
That's something I wanted to bring about because I have seen tenants pushing, I want an exit clause in the lease. The Kenyan law does not provide for that in totality. And that is why you'll find you will sign a lease and then you will have what you call a comfort letter or a side letter that needs to be registered with the lease at the same time.
Yes.
So that gives you a leeway of comfort. And these are some of the unconventional ways you're seeing landlords adopting to the market to accommodate tenants' demands. We're in a very strong tenant market. And probably I need to do an episode just to educate you on what a tenant market means and what a landlord's market needs. For sake of clarity of this episode, I would say a tenant's market is where there's so much supply in the market in terms of office space, business premises, residential houses, and landlords are literally negotiating with tenants. So tenants dictate the terms of engagement. This is, I want to an early exit. Then you have to see, how can I legally accommodate this? So with that said, in terms of residential evictions, where we find people, like a lot of people are coerced by landlords, honestly. And I always feel like there needs to be a body to advocate for tenants' rights in the residential section. Because they come somewhere, you find the landlord has gotten inside your house, all your things are out, or even locked your things out. And that's
or literally
that's
some
illegal.
lock them in.
Yeah. Could you educate us more on that?
Right. So, guys, there's the Rent Restrictions Tribunal, right? And it's governed by the RRT, the Rent Restrictions Act. And this is where you can take your grievances as a tenant, either by way of the rent is being changed or you have any grievance with regard to eviction, strictly for residential premises. When it comes to commercial premises, you have to go to the Business Premises Rent Tribunal, right? There's a whole statute that governs that as well. So that the processes are very different because of the nature of residential and commercial. Yeah. So first of all, the thing people need to know is because they're not courts, they're tribunals, the filing fees is very nominal and you can represent yourself.
How much are we looking at?
Nominal. See me for consultation, I'll tell you.
Okay.
When I tell you can file it yourself, I can't give you everything so that you now come and pay me consultation.
Okay.
But it's nominal so that it encourages even the most basic mama mboga. If she's being thrown out of her house illegally, then she can actually run to the tribunal and say this is the procedure. You do not need to come, unless you have a lawyer, then you don't need very long drawn out court documents. You can actually just go and then the court will guide you on exactly what you need to do, because once your landlord has either locked you in, locked you out, or locked your things out, or welded the door shut, you need, recourse. There are also landlords who up the rent to force you out.
Yes.
That has actually happened. Now there's an emerging trend of that happening. So they low-key don't tell you, I don't want you anymore.
Yeah.
They just give you a notice that as of October 2024, 1st of October, the rent is now 40,000. And you were paying 20. So you've doubled the rent because I can't afford it. Already I'm struggling with the 20. I'm evicting you. You're not allowed to do that. It is illegal for a landlord to up the rent to throw you out.
What's a reasonable notice because I've seen in commercial space it's stipulated in the lease that rent is going to escalate at this point.
Right.
But then in residential, you sign 1 year.
Yes.
Then the landlord sits down and is like, okay, I'm going to...
Yes.
And you get a rent increment, but there's no notice that has
Yes,
been shared,
yes.
which is very wrong.
It's very wrong. You're supposed to give at least a notice equivalent to the security deposit period of the security deposit you've given. That's actually what is provided for. So if your security deposit and rent is for 2 months or 3 months,
Yes.
then that is the notice you're supposed to give equivalent to that for increment of rent. It is the safest thing to also guard a landlord from a lawsuit by a tenant when it comes to the aspect of increment. And mark you, as a tenant, it is your right to also dispute increment. So, but
Mention
once,
that again, because
That's
that's
my
actually
camera.
this one.
as a tenant, it is your right to dispute a rental increment. But this is the trick to it. They will give you notice and you'll have at least 30 days within which to respond in writing. Don't send a text. If they sent you a letter, write a letter back within 30 days and state your reasons, and don't be rude about it. Remember, in a dispute also, you can be very cordial. Like us lawyers, we don't just
Yeah.
abuse each other.
Yes.
So write back and say, dear landlord, this is thank you for your letter dated this and this, and this is why I am disputing this.
Your
I
increment.
know you're saying this is the situation, but this is my situation. I have kept, and also in disputing it, you have to raise substantial issues. For instance, you have kept the premises in good order. You have been the longest tenant still in that building.
Yeah.
You know, things like that would sway the landlord to say, okay, for you alone, I will retain it, or I'll only tack on 1,000 shillings.
Yes.
So what you want is to get the favor of the landlord. So your language matters. How
Quite
you
a lot.
approach your landlord really matters. A lot of people are very antagonistic to landlords, so it doesn't help your case. If you want any changes to your premises for the better, you want to make it habitable, you want to make sure safety procedures are kept, you want to make sure that whatever you're paying in terms of security, not security, but a service charge is taken care of. The more you bash your landlord, the less it will be done.
Yeah.
So you need to be very careful.
That has always been my role. I tell my tenants, if you want any favor from the landlord,
Right.
make sure that you're in good books
Right.
with them. Now, let's look at, you've done all your tenancy. You're at the end of exiting. You've not been evicted.
Right.
All right? But now you're coming to an end. As a tenant, I decide I need to change my location. I need to change my house. Let's look at the rights of that tenant, and I want to bring a very thorny area of security deposit refunds. Okay? I'll just mention my experience in that spectrum. I've seen tenants where they would tell you, I want to vacate end of March. I mean, let's say end of December. And since I'm holding, or rather the landlord is holding through the management company, 3 months deposit, they will tell you they're not going to pay for the next 3 months. All right? Now, a rule of thumb that I need to explain to everybody out there. Security deposit should not be used to reinstate your rent arrears. Because at the end of the day, the reason why you paid a deposit, it serves as security to the landlord. It does not earn interest. And at the end of the day, when a landlord realizes that I'm having a problematic tenant, what they do, they will not wait for you to get to 3 months so you leave. That's why we push for rent payments as early as after the first 1 month.
Right.
To make sure that they're covered within but
period.
then you have gone all the way to the end. You've not incurred any problems of, late payments, and then you tell the landlord, I want my deposit to be my rent for the last term of the lease. Now, there's disputing the repairs. How does the law protect? Because that's where also tenants are taken advantage of.
Right.
The landlord becomes too headachy in terms of, I want you to use this contractor, I want you to do A, B, C, and D. And do we have, like tenants, do they have a right to ask? Can we sit down and agree what repairs?
Right.
And can I dictate who to use?
Yes.
That's a very gray area.
Okay.
What does the law provide? And if something doesn't happen in that direction, what needs to be done?
Okay. So first I'll say something that a colleague of mine in the profession usually says: the law is not as emotive as we would like to imagine. So it does not make provision for absolutely everything. But what it will give is the bare minimums of the fact that security deposit is going to be paid to the landlord, and then it is refundable upon exit. But now what is in practice and what is being enshrined in lease agreements and in tenancy agreements is that the security deposit does not offset maintenance, repairs, or failure to pay rent. And that is a standard. We say it's in the what is called the boilerplate clauses. So if you have an agreement with 18 clauses, it's probably clause number 15 over there, that just above the clause on dispute resolution. The last one is usually the law of Kenya,
Yeah.
superintends over this agreement. So thereabout, you'll find the clause is talking about the security deposit does not offset all of those. Now, you as a tenant, it is your right to also request that at the day of inspection, first of all, do not inspect when your furniture and fittings are still
Yeah.
in the premises. It is very difficult to get a full picture of the extent of damages, in
Yes,
quotes,
yes.
to the premises. Then, during the time when you are doing this inspection, with no furniture, no curtains, no fittings, nothing on the premises, have your your experts, your what do you call them, your consultants, right,
Yeah.
present, and have the landlord also invite their consultants to be present. The reason for this is that you can have a meeting of minds with regard to the extent of the damages and repairs to be done, how long that will take as well, because if it eats into the next month after you've left, the landlord might be tempted to charge you rent for that other month. So you want to determine the time taken, the extent of damages and repairs to be done, together with the cost. Now, this is where the issue usually lies, where the landlord, if you do not come with your expert, your consultants, the landlord will insist on it being done by someone who most of the time seems to be very costly. So that now the tenant then is forced to say, listen, you can eat into the security deposit. Because for the landlord, it's a safe space. They don't get to refund you anything.
Yeah.
But for the tenant, this is not a safe space, because most tenants are relying on that to be able to pay deposit for somewhere else. Now, what you need to do is always have your experts there, have your consultants there, talk about or everything with regard to the repairs, and then move on from there.
Yes.
Yes.
Oh, wow. Let me just say it's also important for every tenant out there to join like an advocacy support group. Property Chat with Lucy is one of those platforms you need to plug in, because we are informing you, we are educating you. And as we close down, I want to just emphasize on the importance of having a realtor and having a lawyer. It's a long-term commitment that you will need prior and during support, like during the tenancy, prior consultation before you jump into the tenancy, and also you have a smooth exit at the point where your tenancy has come to an end. Any advice to tenants out there?
Again, trust no one. Best advice. Don't even trust your gut, because you see, the
Yes.
due diligence aspect will cover you. Always think with your, what did I say in the other episode, think with your head, not your heart.
Don't assume.
Don't assume anything.
Yeah.
Just because someone told you something doesn't mean that's the fact on the ground. The reason we talked about all these professionals earlier is because the landlord will say something, but when you use the professionals, the facts don't lie. The science won't lie.
That's true.
The measurements won't lie. Ukishikwa na shock kwa stima, it won't lie. So don't trust anyone. Trust only the facts. Do your due diligence and make sure you use registered professionals. Always use registered professionals.
I would love to hear your experiences as tenants. Please just drop a comment in the comment section, and perhaps we could have another episode where we can talk about it and give you a bit of advice on those elements and also navigate wisely during your stay in your tenancies. Thank you for watching. I will definitely see you in my next episode. Please subscribe, like, and let's grow this platform to higher heights.